Hi. I apologize for not doing a video last week, first and foremost. But let me tell y'all, my booty hole was on fire, okay? My booty hole was on fire. The whole house had the stomach virus. We were sharing that bathroom like it was nobody's business. It was a crazy week last week. That stomach bug lasted a whole week. I was in bed the first couple days straight sleeping. I'm sorry. I could not get up. My body was sore. My body was hot. My body was cold. I was over here shivering but hot. My booty hole was not all right yesterday. Not yesterday, last week. But we're here now. We're here this week. And speaking about booty holes, you know what reminds me of a booty hole? Diddy. Let's speak about him, all right? So last time we checked, Diddy was trying to get released on bail. That's where we left him at. Anything other than that was boring as hell. We didn't need all that fluff information. But now, Diddy put in a motion to request another bail for the third time. Now, if you don't know, he already had 2 judges deny his first 2 attempts at bail. His attorney now is filing for a new, and I quote that for a reason, new motion for bail. Now that this third time is coming up, the lawyers asked yet again if Diddy can be released and proposed a far more robust proposal than the previous one. However, that is not even the case. All the information that they relayed to the 2 other judge is the same information that they're relaying to this third judge. Okay? So the government is combating this, and we got some information. We got some information, okay? So I'm gonna read you these court documents, and we just gonna go into it, okay? This is just tea. Now, this is a 30-page document that the government issued out to the judge, and the tea about these documents is not only did they find more witness tampering, but they raided Diddy's jail cell. Okay, so let's go into some of the background into these documents. All right, the first little screenshot that I did was the court should reject the defendant's attempt to reopen the bail hearing based on the same information he presented to Judge Carter. The defendant's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. So they're basically saying, bruh, he just relisted a whole bunch of things that he said prior to this one. So why would you accept it if the other 2 previous judges denied it? That doesn't make any sense, Judge. Okay, that's what they say. All right. As set forth below, the defendant assures that the court should consider new information relating to the defendant's relationship with victim 1 and his communications with various witnesses as a basis to reopen the bail hearing. But these allegedly new facts are the very same arguments made by defense counsel and rejected by the district court previously, dressed up with recently produced discovery. So they're basically saying, they're giving you the same information and saying that it's a new discovery. We already knew this. They already knew this. And since you're a new judge, he trying to play in your face. Okay, that's what they saying. Let's go to the next slide. Boop. Furthermore, Your Honor, the defendant contacts with witnesses demonstrate the threat he possesses to the integrity of these proceedings. All right, Judge. Not only is he playing in your face, He's trying to play the whole court system. So let's read it. The defendant attempts to spin his contacts with witnesses, including witnesses served with grand jury subpoenas, as evidence rebutting the government's proof of obstruction fail in their entirety. All right. So, for example, the defendant, meaning Diddy, claims that the government misled the court and concealed the actual content of the communication between the defendant and the witness who was served a grand jury subpoena in June 2024. All right, so we're going to get into what Diddy did to this witness that was subpoenaed to the court. It says phone records show that between the end of 2022 and January 2024, witness 1 occasionally contacted the defendant Diddy without any response from Diddy, the defendant. That changed all of a sudden in June 2024 when witness 1 was served a grand jury subpoena on June 19, 2024, and after contacting the government, which is, I guess, a step he has to take to get appointed, was appointed counsel June 25th, 2024. Beginning on June 26th, 2024, only after witness 1 has been served the grand jury subpoena and had counsel, the defendant, Diddy, initiated contact with witness 1, which the defendant attempted to obscure by initially calling witness 1's wife and later communicating with witness 1 over a VoIP service, including a text and call lasting over 7 minutes. Now, I don't know what a VoIP service is. Let me see. Oh, is it one of those Google numbers? Voice over IP. It's a technology that converts your voice into a digital signal, allowing you to call directly from a computer, a VoIP phone, or other data-driven devices. Simply put it, it's a phone service delivered over the internet. Boom. Screenshotted that for your information. The following day, phone records indicate that witness 1 spoke to counsel for the defendant, meaning that witness 1 was persuaded by Diddy to talk to counsel for Diddy, to talk and say, hey, remember that story I told y'all guys before? That ain't real. This is the story, and I'm defending Diddy and what he did and did not do. Okay, I'm defending him now. Even though witness 1 was represented by counsel, he and the defendant continued to directly exchange text messages, and defense counsel also spoke directly with witness 1 again on July 8th, 2024. Following witness 1's testimony in the grand jury on July 25th, 2024, the defendant called and texted witness 1 again. Okay? Y'all got that? Y'all got that. Furthermore, not only did Diddy reach out to witness 1 and have him change his whole story, according to the government, if you look at the footnote, it says, bank records show the defendant, Diddy's payments to victim 2 as recently as mid-September 2024. The government has requested and is awaiting updated financial documents through the present. So they want to see all those documents. They was like, hey, you want to pay our client? You want to pay our subpoenaed grand jury counsel? You want to pay him to be in defense of you? I bet we got you. We want all of those bank statements. We want all of them up until today. Okay? We want all of them. Give them to me. Okay? That's what they said. Now they have a witness number 2 that Diddy is allegedly being in contact with. Okay? Witness 2 is apparently a girl, a woman. Okay? The defendant reached out to witness 2. The defendant, remember, Diddy, defendant Diddy, reached out to witness 2 on September 11th, 2024 and sent her a copy of the lawsuit against Diddy, in which witness two's name was mentioned several times. The defendant then called witness two and they spoke for nearly 6 minutes. I wonder what they were speaking about, since you want to pay off other people. I wonder what little agreements y'all was speaking about for 6 minutes. After reading the lawsuit, witness two called the defendant Diddy back and at his request, and they spoke for over another 4 minutes. Evidently, the defendant and witness two discussed witness two drafting of a statement as immediately after the call. Oh, I read that. I was like, wait, what? If I fuck up, excuse me, okay? Excuse me. Evidently, the defendant and witness two discussed witness two's drafting of a statement as immediately after the call. The defendant told witness two in a text message, unfortunately is redacted. Supposedly, he says something about, yo, witness two, if you draft me a little statement, all right? If you draft me a little statement and post it, I got you. Allegedly. It's redacted, so we would never know exactly what he said, but allegedly, that's what went down, okay? Only the government knows. Only Diddy knows. Only whoever witness two knows exactly what happened, all right? Because for us, unfortunately, it's redacted, all right? From September 11th, 2024 through September 15th, 2024, the defendant, Diddy, and witness two exchanged multiple texts and multiple calls, at least 128 phone contacts in total. So that's text messages and calls combined. 128 is a lot, okay? Unless most of those were text messages, but 128 is still a lot, I feel like. Throughout these phone contacts, the defendant, Diddy, repeatedly asked witness two when she planned to post her statement. Witness two ultimately made a statement about the lawsuit via Instagram post on September 13th, 2024, and all of that is redacted, all right? I wonder what it said, but it's redacted. And here comes the juicy part. Then, after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell during a pre-planned nationwide sweep of BOP facilities. Y'all, they raided his cell. They raided his cell and found a little note. And in that little note, apparently there was a strong inference to be drawn from the defendant's communications with witness two and his personal notes is that the defendant, Diddy, paid, yet again, witness two after she posted her statement. I wonder what that note said. Exactly what that note said. But it's redacted. But there's a strong inference. The government lawyers are saying is a strong inference that Diddy paid witness two for that statement. So under that, I'm going to just paraphrase. It says that witness two, even though she was appointed to counsel, she decided to speak to Diddy. And not only did Diddy pay her, but we can infer from that he fucked up the fucking witness. He tampered with the witness. He what you accused him before, he's actively doing it right now. Remember the two judges was like, nah, fuck that. You staying in jail for witness tampering. He's still doing it from jail, Your Honor. Like, you gotta be kidding me. You have to be kidding me. Paraphrasing. All right. To continue, they kind of summarize why Diddy should be left in jail. Under this paragraph, it says the defendant cannot rely on section 3142I for his release. The government lawyers are saying, hey, we got to break this down smooth and simple for you because we know you got a lot on your plate. We don't think you're stupid, but we think you're a busy man. You're a busy man, Judge. Or is it a girl? I don't know. But you're a busy person, Judge. We got to break this down plain and simple. Number one, numero uno, the defendant cannot rely on section 3142I for his release. Like, what the fuck is he doing, Judge? What's he doing? Me and you know that he does not qualify under those terms for a release. And I'm gonna explain to you why. Okay? The defendant, Diddy, moves for a pre-trial release under 18 USC 3142, claiming that the defendant cannot adequately prepare his defense at the MDC. MDC is the jail he's in, Metropolitan Detention Center, okay? The law does not support the defendant's release under the provision either, as the defendant has amply been afforded reasonable opportunity for private consultation with counsel. All right, they saying you stupid, Judge. They saying you goddamn stupid. They over here saying that he's not allowed a laptop and a pen and he's not allowed to talk to counsel. Bruh, that's what's he saying? What's he saying? All right. First and foremost, Judge, the MDC has provided the defendant with more than reasonable accommodations to meet with counsel. All right. He has even more freedom than all these other people jailed up, Your Honor. Why did that come out so southern? He has more privileges than any other jailed person up in there, all right? He's trying to play in your face, Your Honor. The defendant is permitted to meet with the counsel 7 days a week and regularly has access to a separate conference room off the common area of his unit. In fact, records indicate that the defendant has met with defense counsel most days since his custody. So what the fuck is he talking about, Your Honor? All right. This part is a long section. I'm only going to read the highlighter part. It says records also indicate that the defendant frequently communicates to his attorney by telephone, written communication. So what the hell is he talking about, Judge? He got a pen. How you writing without a pen? You writing with your blood? I don't think so. Including, as explained below, through unauthorized means. He's also doing this through unauthorized means, Your Honor. And his lawyer knows it's unauthorized. So you better go check up on him, all right? Go hold him in contempt, however that works. I don't know. But even if the defendant were only using authorized channels of communication, the MDC's procedures do not infringe on the defendant's, Diddy's, constitutional right to effective counsel or to participate in his defense. They basically saying, hey, if he has extra rights and he's saying he don't even got a pen, Your Honor, we have to reconsider this whole jail thingy, because that means the other inmates also don't have the constitutional rights. But here is proof, Your Honor, that he's lying. Straight in your face, lying. Even his lawyer is lying, because Diddy is contacting his lawyer through unauthorized means, Your Honor. All right? Okay, moving on. All right. Again, I'm going to only read the highlighted part, but the top part says the defendant poses a serious risk of obstruction, danger, and flight. Accordingly, the court need not to make a determination regarding the defendant's risk of flight or dangerousness. However, even if the court were to analyze the factors in 18 USC, again, the court should continue the defendant's pretrial detention because no condition or combination of conditions can assure the defendant's appearance and the safety of the community, nor can conditions prevent the defendant's continued obstructive efforts. The incorporated submissions and arguments presented to Judge Tarnowski and Judge Carter amply support those findings. And as described further down below, the argument for detention has only gotten stronger. So they saying, hey, If all of this I just written up for you has not given you everything you need to deny his bill, let me give you some other things. Let me give you some other things, Judge. The defendant has continued his efforts to obstruct the defendant has continued to obstruct justice in jail, Your Honor. And they title it so professionally. The defendant has continued his efforts to obstruct justice. Okay, highlighted part. However, to the extent there is any doubt that the defendant Diddy risk of obstruction at the time of the prior bail hearings, such doubt is now non-existent. He's saying, hey, if that wasn't enough for you, Your Honor, if you have one shadow of a doubt that what we're saying is not true, or what we're saying does not persuade you enough to keep his ass in jail, Your Honor, I'm going to give you a few more facts that make this doubt non-existent, all right? You will have no shadow of the doubts, okay? Doubts will be dismissed from these facts, all right? Since the defendant has been detained in MDC, he has continued to try to evade the law. And we're going to read that little footnote down there. Since the defendant's arrest, the government has continued investigating the defendant's obstructive conduct and began receiving recordings of the defendant Diddy's BOP calls since October 2020. No, in October 2024. I gotta be real specific. In October 2024, not since. All right. These calls in its entirety will be produced to the defendant through a filler team prior to the bail hearing scheduled November 22nd. That's this Friday, 2024. The government did not previously disclose. What are these accents today? Spanish, Southern, disclose these recordings due to his ongoing investigation, but is doing so now given the recent escalation in the defendant's efforts to influence the jury pool in this criminal case, set out in detail below. Let's look at the details, okay? Specifically, while in custody at the MDC, the defendant has repeatedly communicated with others in ways that violate BOP rules, and they're designed to evade BOP and law enforcement monitoring, including, as described below, using PAC numbers belonging to other inmates to make calls, using three-way calls to contact other individuals, including individuals who are not on the approved contact lists, Your Honor, and using an unauthorized third-party communication system to send messages to numerous individuals, including unauthorized contacts. So he's not only breaking one or two or three of these, he's breaking, hold on. He's breaking 1, 2, 3, 4. He's breaking 4 of these. He's breaking 4 of these, okay? He's breaking 4 of these rules. 1, he's using PAC numbers belonging to other inmates. He's using three-way calls to contact other individuals. He's contacting individuals that are not on the approved contact list. And he's using third-party systems to communicate with these people as well. All right, Your Honor. So PAC numbers, if you don't know, they explain it down below. The government has reviewed dozens of recordings of BOP jail calls in which the defendant uses telephone accounts of at least 8 or other inmates. So PAC numbers are basically other inmates' telephone accounts. All right. They all have an account to the telephone. I guess you type in those numbers, or they have a specific number when you get on the phone, and they use that. All right. They furthermore explain it in this little footnote. It says, when an inmate enters federal custody, he is generally permitted to communicate with out of custody individuals, including friends and family members. All right. To do so, the inmates provide a contact list, which includes the individual's name, phone number, and email address. BOP staff must approve the individuals on the contact list, and inmates are not authorized to contact individuals who are not on their contact list. Additionally, phone calls and emails to non-attorneys are monitored by BOP to ensure that the messages do not jeopardize the public or the safety, security, or orderly operation of the facility. When inmates make phone calls, they are required to use a PAC number or phone access code, that's what that means, that is connected to their unique BOP register number. Inmates access email using TrueLink's system, which is operated by a company called CurLinks. Corrections links, They thought they was cute using that word. TrueLinks is a fee-based system that inmates must pay for to send and receive emails using the TrueLinks computer system. Man, oh man, I wonder who snitched. I wonder who is like, yep, he paying me to use my PAC number. Guards. All right, lawyers, you guess what he doing? Guess what he doing? He's paying me through commissary, to use my PAC number. We're going to read the highlighted part on this one. Other inmates' PAC numbers. The government has reviewed dozens of recordings of BOP jail calls in which the defendant, Diddy, uses telephone accounts for at least 8 other inmates. So not only one inmate, Your Honor, 8. He's paying off 8 inmates, which is against BOP regulations, seemingly to avoid a law enforcement monitoring. The defendant uses other inmates' PAC numbers to make phone calls with both individuals on the defendant's approved contact list, as well as other individuals who are not on the approved contact list. What was Diddy thinking? They listen to all the recordings. They thought they don't listen to all the inmates' recordings. No, they know your voice. Somebody also probably snitched on your dumbass, okay? I wonder how long he was doing this for, because they only got from October. All right? The last month. The 24th at that. Oh, literally probably last month, because this Friday is 22nd. Anyway. To obtain or maintain access to other inmates' PAC numbers, the defendant directs others to pay the inmates, including through payment processing apps and BOP commissary account deposits. So, it's not only those 8 people he is probably paying off. He's probably paying off the other people who are, foot workers for Diddy. All right? So he's manipulating the whole inmate system. The defendant knows this is against BOP regulations. At the outset of each telephone call, the inmate is prompted to enter his PAC number, I guess. I think I cut that off. Yeah, PAC number. After which, an automated recording announces sharing PAC numbers is against BOP policy and is subject to disciplinary action. All right. So, Your Honor, he been through this. They say it on the recordings every single time he has a phone call, all right? He's introduced to these instructions every single time he has a phone call, Your Honor. So he can't even say that he didn't know, right? He can't even say that. He's not deaf. He's not dumb. He's actually smart because he's paying off everybody to do his footwork, all right? To do his little dirty work. All right? He's making foot workers in the jail. Is that not considered a gang? I don't know. Not a lawyer. Anyways, 3-way calling. The defendant also frequently instructs individuals whom he contacted by telephone, including family members and his attorneys, to add other individuals via three-way call. This practice is also not authorized by BOP as it helps conceal the identities of the contacted individual. I didn't know that. I thought that three-way calling is probably okay. I don't know. But anyway, the government has reviewed multiple calls in which the defendant, Diddy, has instructed others to dial in third parties, including members and associates of his enterprise. You know, the ones he's paying off to do his dirty work, and individuals who are not on the defendant's contact list. Let's go to the most interesting part: non-authorized messaging services. In addition to flouting BOP rules regarding phone use, the defendant also uses a non-authorized third-party messaging service called Contact Me ASAP. To obscure his communications, the defendant appears to be using two contacts under Contact Me ASAP. First, the defendant's BOP contact list includes a particular email number 1, assigned to the defendant's son, which does not appear to be an account owned by the son, but instead appears to be an email address connected to Contact Me ASAP. Secondly, the defendant appears to be using another inmate's Contact Me ASAP account, primarily using email number 1. The defendant has exchanged hundreds of text messages via Contact Me ASAP with dozens of individuals, including attorneys and individuals who are not on the defendant's contact list yet again. The defendant's repeated circumvention of BOP regulations, starting almost immediately after arriving at MDC, speaks volumes about his ability to comply with any conditions under his release. They saying if he can't comply to these rules and regulations in jail, Your Honor, what makes you think he'll comply to them under his release? You give him more freedom, he gonna run a mile, Your Honor. He might just run more than a mile, okay? He might just run out of this country, all right? All right. I did not know that you can have a phone in jail. But wait, there is more. So not only is he contacting people through unauthorized means, Your Honor, he's using these means to obstruct and subvert this criminal proceeding. The defendant's intentions are reflected in his own words on the BOP calls with a network of family members and associates whom the defendant has tasked with executing his will. On multiple calls, often using the PAC numbers of other inmates, by the way, the defendant is explicit about his intention to use public statements to alter public perception and beep. We don't know what that says. It's redacted. The defendant leaves no doubt that the narrative he wants to beep is the potential jury pool's perception of his criminal proceedings. All right. Everything's redacted after that. All the examples redacted, but we can assume what the lawyers are saying is correct. The defendant continued these efforts after the court's October 25th of 2024 order request by the defense prohibiting exactly this sort of conduct. Remember, I never spoke about it, but they was trying to get the public to stop talking badly about Diddy. So they put in a order to try to, I forgot what it's called, but a gag order. That's what it's called. A gag order. Okay. I think Diddy was like so happy to see the word gag and was like, oh, let me just throw it on all the people who are talking shit about me. No. They released the gag order. They tried to permit the public from releasing social media campaigns against him, but the defense is doing exactly the same sort of conduct, but instead, they're releasing social media campaigns to try to persuade the public eye in defense to Diddy, okay? So after the court entered that order, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday. Y'all all saw that video. If they put this birthday campaign out with the intention of influencing the potential jury in this criminal proceeding. All right, they're using social media like all these stars do, like all these public figures do, like all these social media influencers do. When they get in trouble, they using social media, and they issuing a PR campaign so the jurors could feel sorry for his dumbass. All right, Your Honor, this is not a new thing. We know these PR tactics. Like, this is nothing new, Your Honor. At the defendant's carefully curated direction, the defendant's children posted a video to their respective social media accounts showing the defendant's children gathering to celebrate the defendant's birthday.
Say to Daddy, happy birthday to Daddy, happy birthday.
But, Your Honor, let me inform you about one little thing, Your Honor. The defendant then monitored the analytics while he was in jail and explicitly discussed with his family how to ensure that the video had his desired effect on the potential jury members. I want to hear these recordings. Not him going on the phone like, yeah, I saw the analytics. Yeah. Yeah, I just want you to paint me in the light so the jurors could get off my fucking back. All right. Not him saying that over the phone. Like, you know they listening, bruh. The defendant does not stop there. No, Judge. During other calls, the defendant makes it clear his intention to anonymously publish information that he thinks will help his defense in this case. And they redact that information. And they just go on to say that this information that he wants to release is in a form of a video. Diddy's efforts to obstruct the integrity of this proceeding also includes relentless efforts to contact potential witnesses, including victims of his abuse, who could provide powerful testimony against him. For example, and they give an example that's redacted once again. Sorry. The defendant is a danger to others. Point blank, period, Your Honor. Final statements, conclusion. In conclusion, I'm paraphrasing here. They're saying, Your Honor, in addition to failing to meaningfully give you proof that he is not going to be a risk to this case, obstructing justice, he also spends no time addressing the significant acts of physical violence that the government highlighted in the initial hearing. So not only is he obstructing that justice from inside, if he is released, he can enact physical harm to my witnesses, to my already victims, to everybody who's out on this case, okay? There's evidence supporting the defendant's long history of abuse, including witness testimony, communications, photos and videos, police reports, and other materials. This demonstrates the strength of the government's case against the defendant. All right? The defendant acts of violence show there is no condition or combination of conditions that will adequately safeguard others and the community. And they saying, see, Judge, this law right here, see 18 USC 3142 G34, See that. See what I'm talking about there, all right? Please. But anyways, moral of the story is Diddy is doing more criminal activity behind bars, and I don't think he's going to be released due to all these new findings. His jail cell got raided and he's a little bit tight about that. And they just proved every aspect of his new proposed and robust bail proposal completely wrong. They're like, fuck out of here, Diddy. Don't play in our faces like that. But anyways, like, comment, subscribe, and shout out to that surprise witness TV. She is actually the one that helped me get these documents. So shout out to her. I didn't really ask her. I just looked on her thingy. If you want to, I just looked at her videos and saw like the case number. If you type that case number in, you'll see all these documents on under the Diddy situation, blah blah blah. I'm just telling you how to get here if you want to look at those documents by yourself. But hey, if you don't, I'm here too. And she's here too. She actually explains it better. She is a lawyer, or was a lawyer, and got rid of her license by herself. Not to any of her wrongdoing. She was just like, fuck out of here. Boom. But anyways, that surprise witness TV, shout out to her. Watch her videos. I'm gonna link them down below. But in the meantime, I'll see you guys later. Yo, I just read 30 pages of the Diddy filings because Diddy wants to be out there like, I want bail, all right? He wants to be out there like, bail. And the government just responded back, fuck out of here. Furthermore, fuck you mean, bitch.